So I'm going to be talking about developments in the Victims' Right to Review scheme, specifically as it applies to the Crown Prosecution Service, because of a recent case that was handed down by the High Court, as set out on that first slide. Why I've picked this topic is because it's something that I find is often unknown to practitioners who work within the context of the trial process. If we're prosecuting a case or we're defending a case, rarely would we encounter a situation that involves a victim's right to review, given that it involves this third party, the complainant. And also the statistics that have been recently released by the CPS as part of their annual data indicate the number of applications that they receive under the Victims' Right to Review scheme is very low. Between the period of April 2018 and March 2019, the CPS made just under 95,000 decisions which could have been subject to review under this scheme, but they only received just over 1,900 requests for review. So that's of all of the decisions that they had, only 0.22% of cases were actually subject to this review scheme. So it's a tiny proportion of the cases that go through the system that would be eligible, but also, of course, within that, a tiny proportion that we would ever encounter. And the most common sorts of offences that fall into the category of these review are offences against the person and sexual offences by some stretch. So the next slide. So here we set out where this scheme originates from. It's actually been in force since 2013, and it came into being as a result in part of common law and then this European directive that establishes the minimum standards on the rights, support and protection of the victims of crime. And it was made clear at the outset of this scheme coming into being by Keir Starmer, Queen's Counsel, who was then Director of Public Prosecutions, that the function of this scheme was essentially to put the victims at the heart of the system and to protect their rights and interests. Now, on one view, that has long been the case, but it was seen at that time, although it was already reflected in the Code for Crown Prosecutors, that more needed to be done to correct the historic imbalance between complainants and defendants within the criminal justice system, and also to ensure that those who were affected by the CPS's decisions could hold the CPS to account. And so it was made clear by the CPS at the time of bringing this into being that this scheme recognises the active participation of victims in the criminal justice process and ensures or seeks to ensure that their rights are protected and can be enforced. Next slide, please. So the common law origins, just by way of background, come from the case of Killick in 2011, where the Court of Appeal made clear that the CPS is bound to review its decisions not to prosecute if it is requested to do so. And the purpose behind this was because of the various interests that are part of the prosecutorial process, the interests of the state, the defendant, and the victim, and because of the finality of the decision for a victim, where a decision is taken either not to charge or not to continue with the prosecution where it has already been instituted. Now, the same process, I should add here, as is alluded to by the Court of Appeal, does apply to the police. Victims' right to review schemes exist for police forces around the country, as well as other prosecuting agencies, local authorities and the like. It's not just unique to the Crown Prosecution Service, though of course each of them will have their own guidance. Now the next slide sets out the origins in EU law, which is this directive that came into being after the case of Killick, but of course before the CPS's VRR guidance was published in 2013. And as I've said, this establishes the minimum standards on the rights and protections for victims of crime, and it makes clear in Article 11 essentially what caused this VRR scheme to be established was the requirement that victims have the right to a review of the decision not to prosecute. The procedures and the way in which that scheme works is left to national law. But this directive makes clear that, for example, victims have to be notified without unnecessary delay of their right to review. They have to receive sufficient information to decide whether to request a review of the decision. The reasons for the decision should be provided through a copy of the document, and it should set out what the decision is. So, for example, a decision to offer no evidence or a decision not to charge a suspect in the first place. And then it should also provide a brief summary of that decision. The directive also makes clear that a review of a decision not to prosecute, or indeed subsequent decisions that result in no prosecution, should be carried out by a different person or authority who made the original decision. So all of these principles we see when we come on to the next slide, and explain how the scheme operates for the CPS. All of these principles are set out within the CPS's VRR scheme. So the next slide, please. So here we've just got a small flow chart to set out how the scheme operates. This is a general explanation. There are certain circumstances in which the scheme doesn't operate quite in this way, but in principle, there's a two-stage process of review. So where a decision is notified, a decision not to prosecute, the victim in a case who is defined by the CPS's VRR guidance as any person who has suffered harm, including physical, mental or emotional harm, or economic loss, which is directly caused by criminal conduct. That person will be notified of the decision not to prosecute and then informed of their right to seek a review if it is a decision that is susceptible to this review scheme. Why that's important in terms of eligibility is because the guidance sets out a number of kinds of decisions that are not eligible for this review. There are four main decisions that are set out in the guidance that make clear are qualifying decisions for the purposes of this scheme. But of course, there may well be circumstances where the CPS offer this right to review, even though the guidance would not otherwise provide for it. So the four main areas for decision: the decision not to charge, the decision to discontinue proceedings, either in the Crown Court or the Magistrates' Court, or to withdraw all proceedings in the Magistrates' Court, offering no evidence in all proceedings, or asking the court to leave all counts to lie on the file. And so the victim in the case will be notified of one of these decisions and their eligibility to seek a review. And then we move on to this local review stage, which is clear in the middle of the slide. That's the first stage of review. And what that means is that the decision not to prosecute is considered by the local CPS office. So they will assign a new prosecutor to look at the decision, take the opportunity to ensure that a proper explanation has been given where it hasn't been provided previously. And then they will consider whether the decision previously taken was wrong. And the two outcomes essentially are they can recommence proceedings where that is possible, or they can uphold the decision not to prosecute. And I say where it's possible because, of course, where no evidence has been offered in all proceedings, there is no way to recommence those proceedings. So in that situation, if it is concluded that the decision previously was wrong, an explanation will be provided, and where it's considered right to do so, the CPS will offer an apology. Where the original decision is confirmed as correct, then additional information or an explanation can be provided also. If dissatisfied with the outcome of that local review, so presumably because the decision is confirmed as correct, then there's the second stage of review, which is the independent review. And that generally is considered by the appeals review unit. But there are particular situations where it would be considered by the Chief Crown Prosecutor or the head of a complex case division instead. That generally is where the decision to offer no evidence or where reinstitution isn't possible. Otherwise, it would go to the appeals review unit. And effectively the same sort of process again. So there's a further review, a reconsideration of the evidence in the public interest test, and the new reviewing prosecutor will again approach the case afresh to determine whether the original decision was right or wrong. And again, the outcomes either commencing proceedings where that's possible or upholding the decision not to prosecute. Now, if the decision is found to be wrong and a prosecution is required to maintain confidence in the criminal justice system, that's effectively the test for overturning the original decision. But it's only at that point that a suspect or a defendant, depending on the stage of the case as to the name that they're given, that's the point at which they would be made aware of the review, because previously they would have been told that the case won't be proceeding, there isn't going to be a prosecution. They wouldn't otherwise be made aware that a victim has sought this review unless the position changes and that original decision is overturned. The court considered this in a case called S in 2015, the Queen and S and the CPS, where a defendant sought to make representations to the Crown Prosecution Service about continuing a prosecution against him. And the court made clear there that there's no opportunity within this scheme for a suspect or a defendant to make representations about the continuation of a prosecution, or indeed the decision at the outset to prosecute him. This scheme is effectively, as it says on the tin, it is for victims. So defendants pay no part ultimately in this scheme. Now, in terms of time limits, there is a degree of flexibility, but the guidance makes clear that requests for review should normally be made within 5 working days of receiving the decision, but victims have up to 3 months to make that request, and an extension of time can be granted in exceptional circumstances. So there is an element of discretion, and certainly where decisions are taken on a local level, anecdotally, there is a fair amount of variation as to the amount of time granted for an extensions, the sorts of reasons that would permit extensions to be granted, and the like. Now, after these 2 stages have been carried out, I probably should have included a 4th box there, but the remedy after that, if dissatisfied with the decision on review, is judicial review. So the next slide. Now, why is this scheme so important? Well, the key thing really is because, as I said earlier in the case of Killick, that a decision not to prosecute is in reality a final decision for a victim. And this is compounded by the fact that courts have repeatedly held that where there has been a review under the victim's right to review scheme, and the review has been careful and it's been thorough, judicial review proceedings will be all the more difficult to advance. And the courts have been very clear that in any event, interventions by the courts in these sorts of cases will be very rare. As is set out on the slide, in the case of L, the court made clear that they will adopt this very strict self-defining ordinance, which emanates largely from the constitutional importance of prosecutions, decisions to prosecute, because they're entrusted to prosecuting authorities with their independence, their experience and expertise in making those sorts of decisions, requiring the exercise of judgment to be recognised and respected. And it's the constitutional separation of powers ultimately that makes the court so reticent to intervene. Prosecutors also, because of this, because of their independence and their experience and their expertise, they are afforded a significant margin of discretion. And so there are very limited grounds for the courts to intervene. There's also, because of the judicial review remit for decisions to prosecute after the VRR scheme has been exhausted, there's limited scope for any subsequent merits-based challenge. So the decision can only be challenged on public law grounds. Initially, the courts made clear in the case of L that the grounds for challenge were very, very narrow and limited to lawfulness and rationality. But it's clear from subsequent decisions of the High Court and other courts that, for example, an error of fact is capable of founding a claim for judicial review. And in the recent case of FNM, which I'll go on to discuss in terms of the developments, it was argued there that, for example, the principles of natural justice should equally apply here, and there's nothing to say that there couldn't be a judicial review based around that, as opposed to, for example, lawfulness or rationality. There's also the limited scope, and in terms of the scope for the courts to intervene is also relevant, subject to the kind of dispute that may be brought before the court. Because where the issues involve some sort of dispute as to evidence of primary fact, the CPS's expertise and experience in considering how that evidence will be received at trial is, as the courts previously said in the case of Torpy in 2019, it's a particularly powerful factor. And so the courts will be slow to hold the decision maker's assessment as irrational where it's concerned with any dispute as to that evidence of primary fact. But by comparison, where the issue is one of law, the decision maker's experience and expertise may be of less force, and so the court will be more readily prepared to find an error of law in a case. So if we move to the next slide. Now, against that background, which I've set out really because I appreciate that lots of people may not be familiar with the VRR scheme, what it is, how it operates, and the sort of scope that exists to challenge prosecutorial decisions. The case of FNM and DPP was before the courts this year. Judgment was handed down a couple of weeks ago. And it's really quite an interesting case that I wanted to talk about because of the way in which it moves forward the victim's right to review scheme in terms of its adoption of general principles of public law, rather than merely being focused on the very specific nature of a decision under challenge. So in this case, the claimant, FNM, challenged the CPS's refusal to accept representations from her in the context of a request for review under the VRR scheme, after they decided not to prosecute a suspect known as T for offences of rape, sexual assault against a child, and any other potential offence. The claimant had written to the CPS. She had been told by them that she was at liberty to make representations in support of her review, and that she had until the 27th of September of last year to do so. But then on the 9th of August, and without any notice, the CPS reached a final decision and upholded its original decision not to prosecute T. And so the claimant brought this challenge and submitted that it was unlawful. She argued that there was a right of a fair opportunity to make representations, and this was on the basis of three things. Firstly, the terms, operation and purpose of the VRR scheme. Specifically, that within the scheme, paragraph 42 implies that there will be an opportunity for representations to be made, because the CPS guidance states at that paragraph that where a victim has been given reasons for requesting, a review, the issues raised will be addressed in the decision letter to the victim. So that, it was argued, implied that there was this opportunity for representations to be made, because ultimately, if they're going to be addressed in the forthcoming decision letter, that opportunity must surely exist. Similarly, within the purpose of the scheme, as I've already touched on, was to put victims at the centre. And it's difficult ultimately to take the views of a victim into account without giving them an opportunity to raise those views in any sort of representations as part of this review process. The same basis for this fair opportunity was said to be the requirements of common law procedural fairness. So these emanate from general public law principles that are well established now following the cases of Ex parte Dudi, Bank of Mellat and HM Treasury number 2, and also Osborne and the Parole Board, which is essentially this, that where someone is to be adversely affected by a decision or the outcome here of the review, common law procedural fairness requires an opportunity for them to make representations to seek to procure a favourable outcome. And then thirdly, the basis to make representations in this particular case was said to be that this claimant had a legitimate expectation that arose on the facts, because she had been told she had until a certain time to make those representations and then was denied that opportunity. So leaving aside the legitimate expectation point, really for our purposes, because that of course is entirely on the facts of her case, the first 2 points certainly were dealt with in a very interesting way by the High Court. And they held, and it's set out on the slide, firstly, that paragraph 42, which is the paragraph I referred to before, does give the complainant a fair opportunity to make representations and have them taken into account by the decision maker, accepting that the general public law principles that have been long established do apply. So those principles that are set out in Doody and Bank Mellat and Osborne, that you're entitled to make those representations to seek to procure a favourable outcome. But the court didn't go as far as to say that there is a duty to positively invite representations. In fact, they made very clear that there is no such duty. And so really the opportunity extends, this fair opportunity is only there that you may make representations, but beyond that, there's nothing further in terms of what that right would entail. And thirdly, the court made clear that the complainant doesn't have the right to hold up the review process for a significant amount of time to enable her, for example, to consult lawyers to formulate a detailed case. So this really was, the court certainly implied, something that would have to exist within the scheme as currently formulated, within the timeframes that currently exist, and is not to be a means of essentially further litigation within the context of this review scheme. So moving on to the significance of this case, and the next slide, please. Why I suggest this case is significant is firstly because it's novel, really. There hasn't been, other than the case of S, which dealt with the right of a suspect or a defendant to make representations, there hasn't been, I would suggest, a case this novel in terms of what the substance of the right to review for a victim or complainant entails. Here it's the only case that deals with how natural justice would affect that victim's right. And there's certainly scope for potential further development. So, for example, other areas of principles of natural justice and how that extends to the relevant matters of a fair opportunity to make representation. So, for example, what does it mean for a right to receive reasons, which I'll come on to? That still remains open as a question, and that's not something that the High Court in FNM went on to deal with. I've read a number of articles that have talked about this case since judgment was handed down, and some have said, for example, that this is a case where it's only really applicable to the facts of this case. It's not a statement of general principle, and I wouldn't agree with that. I think that there is, in what the court has said very clearly, that paragraph 42 gives the complainant a fair opportunity to make representations and have them taken into account. That must be a statement of general principle and of application and of importance to practitioners who do this sort of work, that it's clear that that opportunity should be utilised wherever possible, given that the courts have now recognised it exists in accordance with general public law principles. What will be dependent on the facts of each case is the question of whether the right has been breached. So whether your right to a fair opportunity has been breached. Which brings me on to the next question, which is, what does this fair opportunity actually mean in practice? The court gave some indicators, some parameters. So, for example, in relation to time limits, it suggested that unless it was an urgent case, a request for, say, 7 or 14 days made well before the expiry of the 3-month time limit to seek a review is the sort of request that would be sympathetically considered. But beyond that, it wasn't willing to make any further statement or provide any further guidance as to the sorts of time limits that ought to be adopted or might be adopted in order to afford a victim this fair opportunity. Practically, of course, as practitioners, we know that that amount of time is not always sufficient to instruct a lawyer, to take instructions, to draft representations, or perhaps to do all of those things, particularly if someone who's seeking to undertake a review doesn't get in touch with a lawyer until the point where they have submitted that review and then seek to submit representations and support. The time limit point might not be so relevant if, for example, someone requests this review and submits their representations at the same time, which is of course possible. But it may well be that these time limits cause difficulties going forwards. Equally, how do you ensure consistency when it's down to discretion, when you're asking the decision maker or the reviewing decision maker for that extension of time, and it's down to them to decide on a case-by-case basis whether or not they're willing to afford more time. And it's a similar problem in terms of the review time limits generally. If you are approaching that 3-month time limit and you want to seek an extension, it will be at the discretion of the person named in the letter who you are to direct that request to. There isn't a centralised system that ensures that that kind of consistency is applied across the board in terms of granting extensions of time or not. Now, you can understand the court's concern here when they made clear that time limits were, of course, important in the context of what is otherwise becoming an ever more delayed justice process. And the CPS's figures for the second quarter of last year certainly support the court's concerns in terms of the average waiting time from the initial complaint to the police to a charging decision, because many of those have increased. And in cases of rape and child sexual abuse, that stood in the second quarter of 2019-20 at 132 days between the complaint and the charging decision. So that's almost 4.5 months, and that's an increase from 108 days in the previous year. So for most complainants and defendants, that's months of anxiety, months of time where their lives are on hold. It will affect their mental health, it will affect how they lead their lives. And of course, it's important that this process takes place quickly and swiftly and ensures that that amount of time that everyone is waiting for decisions is not extended even further. Now, the second, we seem to have lost the slides, but the second matter that I wanted to deal with was reasons, as I've already mentioned. What follows from this decision is there an entitlement for reasons for the decision, and what standards would that be too? As I've said, that's already something which is up in the air. This case here, FNM, doesn't assist with that, but of course is important within the context of a case called Chowdhury and DPP from 2016, which states that the VRR scheme must ensure that the right to review of a qualifying decision is an effective right. Now, a fair opportunity to make representations is a means of ensuring an effective right, but you can imagine a situation where that can be rendered meaningless without knowing the basis for the decision, because you can't make an informed decision as to whether you're going to seek a review, nor can you make any meaningful representations if you're not provided with sufficient reasons for the decision not to prosecute. So I would suggest that that's one area where the courts will be particularly keen to litigate when the right case comes along, because it's certainly something that is not clear at present, either on the basis of the guidance or on the basis of the case law, as to what the entitlement for reasons is, how detailed those reasons should be, what the standard of those reasons should be, and whether the general public law principles that apply to the standard of reasons, as many of us will know, is set out by Lord Brown in the South Bucks and Porter No. 2 case, whether that applies to prosecutorial decisions. And then the final significance that I just want to touch on briefly, that's really food for thought, is what about in all of this the rights of the suspect or the defendant? That was something that was raised before the High Court very heavily by the DPP. And as I've mentioned, the case of S makes clear that this equivalent opportunity to make representations doesn't apply to defendants. Is there now, as some may think, an imbalance between complainants and suspects into their input into a case before it reaches a reviewing prosecutor? Or does this case of FNM really put the victim at the heart of the system as the scheme was intended to be? Ultimately, we won't know, and that's probably down to individual thought, really. But it's interesting in the context of how the case law has developed in relation to this scheme and going back to its original purpose as to where that question sits. So those are all of the matters on my slides, and I'll hand over back to Andrew for any questions.